Ladies and gentlemen, it's 2 o'clock, so I suggest that we resume our works dedicated this afternoon to political ethics and trust. Political ethics and trust, these are two notions which meaning is not always clear, at least for me. I have a constitutional law training from the 1990s, but these two key notions, which are invisible, as it was said this morning, but support all democratic systems. So to define what we're going to talk about, even though it was done this morning, without going in depth in this issue, I will come back to these two definitions in an operational objective concerning the speeches of the panel members to try to have a very general view of what we're going to talk about. So I base my work on Céline Romainville and Léna Géron are the authors to be published in the 𝐸𝑁 editions, and they define it as a cognitive and emotional state, a mix of rationality, feelings, commitments of a person that they call the truster, engaged in a social relationship with others. The trust is based on the hope that these trusters will keep their word. And as it was said this morning, that the trustees have a certain degree of freedom to achieve meet the expectations of the trusters. So it includes a certain risk-taking and some vulnerability for the trusters. So as we can see, this is a deeply relational notion, the trust of whom, the trust to whom, and the trust about what. And as it was said this morning, so I'll go quickly, when we talk about the notion of trust in politics, we think of the relationship between citizens and politicians, and the data seem to show that this trust is declining, which has become the commonplace of this loss of trust. And we could also talk about the trust of institutions among themselves, as we said this morning, in terms of ministerial responsibilities in the parliamentarian system. And what we didn't talk this morning is the reciprocal trust that should be between public representatives individually. For example, now in Belgium at the federal level, they are trying to form the new government, so there must be some trust between the elected representatives or political party leaders in order to build this new government. And there's also the trust, as we'll say, with the European Union, between the different powers, with the federal states, the regions, or the European level. So that's for trust. So it's quite operational, practical, and very schematic. For political ethics, Éric Buge has a reference book called Exemplarity of the Governing Powers, published in 2002, in which is a free access. I think it's an audible book, and he defines the legal notion of exemplarity, model of the leaders to force them to virtues. And he also says that it should push leaders to favor the greater good than individual interest. So we'll see different forms, content, objects that can lead to transparency, honesty, avoid conflicts of interest, fighting against corruption, or to guarantee the sound reputation and the optimal functioning of institutions. I think that we can talk about political ethics as a network of behaviors that are apprehended by the rules of law. Now, the question is, what is the link between virtues and trust? So is a role model is a trust. So But what is for sure is that the lack of trust of the leaders when it's discovered is loss of trust in the trustees. So for me, virtue is necessary to trust, but beyond being a role model. So what is this virtue understood as a part of the ethics? So to help us with this line of thought and to open the debate, we have a very good panel with major specialists that will shed some light on their different fields. So French law will be highlighted by Mr. Éric Buge, Belgian law by Mr. Kellenole, and British law Michael Gordon, and Cécile Dumont and Cecilia Rixala will tell us about the European level. And I'm going to give the floor to Mr. Éric Buge. I just want to introduce him. So he focused on democracy and parliamentary assemblies, the citizen participation, and the role model of public figures. He's Maître de requête at the French Council of State. He was also former administrator of the French National Assembly and Secretary General of the Group d'études sur la vie des institutions parlementaires, 𝐺VIPAR. You know, in France, they always have some dark acronyms, and especially he's the author of many contributions to the functioning of the parliament and the citizen participation also beyond the book that I mentioned in my introduction. He's the author of Droit de la vie politique in Presse universitaire de France in 2018. Sir, you have the floor. Good afternoon, everyone. I would like to join the previous speakers in thanking warmly the organizers of this event. With my colleague and friend Jean-François Carlos around lunch, that this was an exceptional conference, having so many legal experts of so many different cultures gathered on a topic that I like very especially, which is political ethics and trust. So when I was when I was offered to speak in this conference, I was a bit surprised by the topic that was offered to me, that is political ethics standards in French constitutional law, not so much political ethics or role model, but I will come back to this notion. But the topic selected is the French constitutional law, and so I wondered whether there were some political ethics rules in France. Maybe I had missed it, and so this is this investigation that I will cover with you. Are there some political ethics in the French constitutional law? And so for my method, I propose to identify and this notion of political ethics that I will identify with the exemplarity of the governments, because in the sake of time, and this was some collective work, because 2 years ago in Paris University there was a conference that allowed to define and conceptualize this notion. So I suggest that we select 3 criteria. This way we can agree on what we're talking about here. So 3 criteria that I will describe slightly to agree on their content. First, there are legal standards that are constraining and that sanction. So it might sound trivial, but I'm referring only to the legal standards. So in everyday life when we talk about exemplarity. We want to cover some standards, some behaviors that go beyond the legal standards, some moral standards, for example, some ethics that may not have any legal basis. And the legal exemplarity, as I want to define it, is a small part of the exemplarity or behavior that citizens may expect. So I'm going to stick to the legal standards. Second criterion is the standards that are to the cost of governments, and also almost discriminatory for governments. So standards that are possible only because they target governments specifically. In other words, if you try to apply these standards to the audience here, for example, and that one of you was to seize the constitutional judge, it's quite likely that it will nullify the case. For example, you have to publish your estate for MPs. If the political power said, I'm going to adopt a law that demands that from all citizens, it's quite likely that that would be an infringement of the freedoms and rights of citizens. So we accept this standard only because it is discriminatory for the leaders and because it's only for leaders. And leaders in the broad sense of the term, it's not a legal term. I take into account both the representatives of the executive power, judiciary power, so all those who have some authority on behalf of the community. It's not the leaders as it is described in the traditional constitutional law. And these rules aim at promoting the virtues of the leaders or politicians, as it was identified, as Montesquieu said, the sense of sacrifice, not not demanding the sacrifice from our MPs, but at least to set aside their personal interests, that is to set aside their own interests to the benefit of the citizens. That's how Montesquieu describes it. So these are three criteria that allow us to define exemplarity and to exclude a certain number of rules that could be on political lives or political actions, ruling out some mechanisms of separation of powers that can have a balance between powers but not controlling and checking the leaders. And we can see also that those exemplarity rules are the opposite of legal exemptions. So immunity, guaranteeing immunity for the leaders, for MTs, for the MPs, for the president in France. These rules guarantee the immunity. They protect specifically the leaders, and they protect them because they are leaders. In opposition, the exemplarity rules apply to leaders because they are leaders. So once we have established this definition, what do we find in the French Constitution? So I said in the French Constitution of 1958, reformed several times since then, you can find in a marginal way some exemplarity rules for the leaders. So what are these rules? First, they are the rules of incompatibility for the different functions. For the ministers, it's Article 23 of the Constitution, setting out directly what is this incompatibility. So you cannot be a minister if you have a personal activity. So the law defines the incompatibility, and the Article 25 describes that. And that's about all that you find in the Constitution for those exemplarity rules in the Constitution. And you could also include the ministerial responsibility rules. So I don't come back to the for destituting the president, there are certain rules to apply. We're close to the exemplarity rules. The president has certain duties, but those duties should be defined. And then if you extend that to the constitutional practice or to the constitutional practices, then we can see those characteristics are quite uncertain. There is the Bérégovoy-Balladur case law that forces a minister who's been accused of something to resign. So that's some kind of protection of the government, some kind of political ethics. That was questions because several ministers have been indicted and stayed in power. So this is something that applied in the early 90s and the end of the 2010, and it's not in the written constitution. Same thing for the ban on having local responsibilities for a minister. That was a French tradition that applied also to ministers. You could be a minister and you can be a mayor or the president of a regional council. Some governments have banned this in practice without changing the constitution, but now it seems that this is a rule that is applied. But there are no exemplarity rules in the French constitution. And the leaders also benefit from some protection, which is set out in the Constitution. So I just mentioned them. The immunity of the French president for all the actions carried out in his responsibilities. And then the different procedures that might be, the proceedings against him are suspended during the presidential mandate. So it's almost a general immunity, very strong immunity for the President of the Republic. And for the MPs, it's the usual immunity for MPs for what they might say during their mandate and the proceedings that might be engaged towards them. So this is a regime that is a regime of protection of the leaders set out by the Constitution, so a regime of protection or immunity set out by the Constitution. But if we look closely this Constitution of the Fifth Republic, we see a new model that is not just for political leaders but for judges. And in the articles dedicated to the judicial powers, there is another model, another corpus of legal rules that could be qualified as exemplarity rules or role models. That's Article 55 of the judiciary. That says that it is a disciplinary institution. Of course, there's no equivalent for MPs. There's no disciplinary body for the MPs. So judges can be submitted to disciplinary measures. And there's a possibility of disciplinary sanctions. So it is possible if you misuse your powers or duties to be sanctioned. And there's also the ethical rules for judges. So you have a whole set with some authority sanctioning, some strict ethic rules, and then the possibility of sanctioning the judges. So this is a exemplarity system that is applicable only to magistrates. And I think that in the French Constitution of the Fifth Republic, there are two constitutional model in opposition, one protecting the political leaders and another one for the exemplarity of magistrates. And by going into the details of the analysis of these two models, we can find some interesting things, I think. Indeed, if these rules are absent from the Constitution for political leaders, in 1958, the legislators didn't turn a blind eye. It's not because there were no rules of conflict of interest that existed in other fields. It's not because these rules are not in the Constitution that there are no checks and controls. But these checks and controls are done through indirect procedures. They don't aim specifically the behavior of the political leaders. They don't prescribe specific behaviors. They are indirect checks and controls, and the main three are there. Maybe it's a bit small on the screen. This is an abstract of the official journal of 1958 that led General de Gaulle to draft a constitution project with some guarantees, and here you have the 5 guarantees that were chosen based on the Constitution. And you can see that in these guarantees, number 1, any power comes from the people, so the principle of election. First guarantee for checks and controls. Second guarantee, the separation of powers. There must be 3 distinct powers, to sub-bullet here. So first, the judiciary power, judges must be independent, and the separation of powers. Third guarantee, the government must be responsible towards the parliament, so that's the political responsibility. And here you have the 3 guarantees of that the representative regimes have to guarantee the checks and controls of political leaders. But these are 3 generic institutions that do many other things than just checks and controls. The elections should make sure that there is an adequation between the political leaders and the opinions of the people. The political responsibility make sure that there is the same view between the parliament and the government. And it's only secondary that these mechanisms ensure checks and controls of political leaders. So the checks and controls guaranteed by the Constitution on political leaders is some indirect control. And through these 3 institutions, it's not specific to the checks and controls of the integrity of leaders, so separation of powers, political responsibility, and independent judiciary. At the same time, and it's quite interesting, over the past 30 years, there was a proliferation of exemplarity rules, as in the US since the 1960s, or in the UK since the 70s. Many other European countries, with scandals, the regulators decided to regulate political life and to make sure that there is the integrity of the political leaders. So you have the 3 main laws, 1988, 2013, 2017, following some scandals. 2018, multiple political financial scandals. And 2013, Cahuzac scandal, a minister having a bank account in Switzerland. And the Fillon scandal, the prime minister who had paid a salary to his wife who was not really working. And every time the Parliament voted laws strengthening the checks and controls and responsibilities of the political leaders. So here you have the exemplarity rules for the ministers. The prime minister was appointed in France in 30 minutes. So what should he do? He will have to declare his estate. He has to place all his financial assets under the management of an institution. He cannot do it himself. Of course, he will have to resign if there's a conflict of interest. We're going to check that he didn't get much richer during his mandate. And following these functions that we hope will be as long as possible, he will, if he wants to go to the private sector, he will need an authorization for this to check that there's no conflict of interest in the different functions. And all these checks and controls will do by an institution which has independent administrative responsibility and powers. In 1980, about 40 years ago, none of these obligations existed. So we are in a development to build some public ethics. And what is interesting is to find out how this new type of checks and controls on the behaviors of the government is articulated with the former checks and controls through the election, separation of powers, and so on. Is it in contradiction, or is it enhancing that? So let's look at what the Constitutional Council said about these new laws that were voted in France. And so here I have analyzed the main 5 decisions of the French Constitutional Council. I won't go into details, but there were 12 provisions that were nullified by the Constitutional Council. So what is interesting is to see why they cancel these rules on the integrity of political leaders. One was because of the separation of powers. So it seemed quite surprising because in both cases it's to control political powers. So why canceling a rule that can guarantee the integrity of the governing leaders? Same thing for the elections and eligibility. So equal access to the ballot was cancelled for these reasons, and I will come back to these 2 cases later on. And then more typical, the right to the protection of privacy, principle of equality in sentences, and the freedom of expression. I will take 3 examples to go into details of the articulation between the mechanism of the protection of the leaders and their checks and controls. So first, on the separation of powers, the Constitutional Council canceled, based on the separation of powers, the possibility for the higher authority for public transparency in independent institutions to send injunctions to the MPs based on the interest. They considered that it was not the role of an independent administrative institution to have checks and controls on the MPs. So on behalf of the separation of powers, including the independence of MPs, so these traditional principles of the checks and controls of the leaders also protects them. These principles that were checks and controls initially, the powers must control one another, but in practice they also protect the political leaders, because the powers must have checks and controls on the others, but the power must be self-organized, not to be subject to the intrusion of the other powers. And that's what the Constitutional Council decided. This administration cannot send them orders on their interests that would be in opposition with the separation of powers. Second example, the provision voted by the French Parliament to check the travel cost of the MPs. We know that this lump sum is a source of potential abuse. So the Parliament had voted a provision to check these costs, these expenses, and it was cancelled because of the separation of powers. They said no, the funds allocated to the MPs must be under the only control of the executive power. So again, the separation of powers protects the governing leaders rather than imposing them checks and controls. As for the equal access to elections, the Constitutional Council also cancelled a ban that the regulators wanted for MPs to be advisors. And because of a certain number of scandals and proceedings in France, the regulators wanted to ban the possibility of being advisors for MPs, and the Council considered that this was excessive because we should not reduce so much the potential activities of MPs, because that was limiting too much the number of people who would be candidates in elections. So all those who are advisors would not take part in elections. So with the elections, there can be checks and controls of the leaders, and that's also a way to protect them, because through elections everyone should be able to be a candidate, so we will control less conflicts of interest for leaders. And my conclusion is that these new exemplarity rules that have been built by regulators over the past 30 years in France and abroad are in pressure with the other checks and controls of the other representative bodies. So it's not an aggregation of the two forms of checks and controls that would strengthen these controls, but we have tensions between those different checks and control models, and we are not at the end of this articulation between the checks and controls of the representatives and the exemplarity rules, which is a new a form to guarantee the integrity of the leaders, and we're still looking for the right adequation for all these rules. Thank you very much.